Test. Test. What's going on, John? Hopefully this is a little bit easier since this is straight through YouTube. That other app didn't seem to do as well. Yeah, I don't have anything on my screen. Yeah. Just a little backdrop. Just the grass. Yep. So let me know. I'm just starting up this live stream just to do basically kind of an impromptu discussion regarding, trust administration, estate management, different things under equity. And just to start, there are definitely a few things that, especially in this space, some things to be aware of is, one, don't commingle remedies at all. I see a lot of people in, self-represented people that are doing mainly just the, more of a legalistic mindset, and if it's, you trying to use the enforceability of a statute instead of trying to, overcome the burden of persuasion, and it just leads to a lot of commingled arguments and arguments that don't have the proper effect that people desire. So number one, nothing that we'll be talking about today is going to be construed as legal advice, tax advice, or financial advice. Like I said, I'm not a licensed professional, and only a licensed professional can give you, actual advice. So again, this is just for teaching, commenting, and training purposes only, and this stuff is covered under fair use. So yeah, but that's one of the biggest things. So number one, when you have any type of issue, it doesn't matter what it is. It could be anything from custody to child support to, probate to civil charges to, municipal or city code infractions. Like, there's a numerous amount of reasons why you can have a matter come up. The key is, how do you deal with it? So how do you deal with matters? Well, for one, you have to determine what the nature and the cause is. Yeah, you should, absolutely. If you aren't claiming that you are the beneficiary under, the interests, your own interests, then who else could ever be, because yeah, you have to come in as the beneficiary um, of your estate. So as the executor and sole beneficiary of your estate. If you don't come in like that, there are more than a couple things that could happen. But that is generally one of the safer routes, provided that you understand the bare minimum of estate management. So, one, like I mentioned in my last video, I talked about care, custody, and control. So, care, custody, and control is something that is very important to understand, not just with regards to, custody and proceedings, but also, business at large and many other avenues, because, you know, those different things are essentially the blueprint of any entity. The blueprint of any entity or any organization that you really need to, to be able to grow it to that point. That's what you're dealing with. So if you're dealing with, say, for example, who is entitled to the proceeds from a business? Well, generally you would say that, without assignment or transfer or some alienation of the proceeds or the interest, generally it falls upon the owners of that business. Well, it's generally a similar aspect of things, with that same model or that same prerequisite, elements of that relationship, that custodial arrangement, right? So you have to effectively manage, for one, who is normally entitled to whatever it is you're basically arguing over. Is it custody of certain res? Is it tangible property? Is it intangible property? Is it IP, intellectual property? Is it copyrights, trademarks? Is it a right of action that is has been assigned or something like that to bring suit against another party for a tort claim or some other type of cause of action. You have to be a little bit careful about claims, because there are certain extinguishments that happen. Like claims get extinguished upon they don't pass the heirs, or you can have a number of reasons why something like that doesn't happen. But yeah, so basically know the nature and the cause of the matter, identify what the normal procedure and the normal presumption of expected results in the court, get a baseline understanding of what is normally done, right, within that particular field of the matter that you're dealing with. Kind of in a similar aspect, there are irregularities and peculiarities, specific to every case, but the general, premises or causes of action, the nature of the suit, those are definitely things that generally will translate across different they'll translate across different suits a lot of times, which is why you have to treat it more on which is where the word statistics really came into applicability with reference to the law, because when you look at cases by statistics, they normally fall on a normal bell curve, right? You have the two extremities, left and right, and then you have the majority of the cases most of the time following into the top of the bell curve, in the median or the middle range of that bell curve, right? Those are considered your standard. There's probably a better word. What's going on? So that's probably a better way to sum up, like, just normal, everyday, standard run-of-the-mill proceedings, right? In equity, most of the things you deal with are not generally just run-of-the-mill proceedings, because so few people understand equity, its jurisprudence, and its available remedies and functions. People do not use equity. So as a result, there's no public precedent that's really as much in favor of equitable remedies. Rather, you have to be the exception and essentially be one of the outliers, generally on the right of the bell curve. You know, right, it depends on someone's perspective, but you want to come out in the litigation, generally from the righteous perspective. So, let me see. So, where's the res? Are there beneficiaries and are they making proper claims? Well, without going too far into it, I mean, it is public, public knowledge. I can talk about that. Um, and I mean, people have talked about it for years. Gene Keating has talked about the bonds, and the court case bonds. Every case is bonded. They have to. Just read clerk's praxis. It tells you. There's two terms that I talk about a lot in the private, and it's fidejucio and fidejussores, which is one, the initial fidejucio means surety or suretyship, and fidejussores is the actual surety. So this is, a practice that's heavily tied into most of the case bonds. Now, like I said, I can talk about the bonds themselves only because they're publicly known and the forms are publicly, available. So you have the bid bond. The bid bond is there for the underwriting of the value of the case, the initial bid, whether or not someone will guarantee, collateral for the quote investment. And, that's one of the initial ones. Now, you also have the performance bond, right? Performance bond is essentially, it's essentially a bond put up, whether by you or on behalf of you, through you, to essentially guarantee and, confirm that you will perform some particular action if you are the one liable on that bond, right? So that is generally how, a general idea of how a performance bond works. Then you have bid, you have performance, now you have also payment bond. So a payment bond is set up upon the contingency of essentially, if a payment needs to be made out, that bond is essentially guaranteeing that a payment can be made out, as essentially, underwritten by those bonds, right? And if you know anything about the primary and secondary markets, then you'll understand essentially how a bond is collateralized, securitized, and then, issued for the public. The collateralization and securitization process is private, and it's also referred to as privatization. But once it goes to a point where it goes through an IPO or some other type of public offering, at that point it's public. So I mentioned the three bonds. Those are generally there. There is another one that most people don't. There are other types of bonds. Don't get me wrong. This is not conclusive as to all the different types, but another type of bond that people need to be aware of is an appearance bond, and this is essentially guaranteeing that you will appear at some particular time or date, before the court. And I won't go into that too much. I really can't in the public. Do they over collateralize in the courts? I mean, from their perspective, what is going to be over collateralization? But the court. The one that loses the suit is going to be collateral for the plaintiff. The defendant can win some as well. For the winning party, the losing party is going to be the collateral for the winning party regardless. As to whether it's over collateralized, I don't know. I'm not quite exact. The wording is a little bit, but yeah. So those are in effect like the four main bonds. Now, The knowledge of the bonds and the fact that they're essentially underwritten, that's public knowledge. If you just understand the jurisdiction, in civil claims, you'll know that. But most people aren't aware of stuff like this. So when you start talking about the administration of the bonds, now that becomes a process, and then it becomes proprietary. So that's what you know. Yeah, they do bond mortgages, but it's just the bonds are different. But yeah. So like I said, and a lot of these different things you have to be aware of. The actual terms on the bond will generally control the conditions precedent to that individual investment or security, or instrument. You'll definitely have to make sure that the way that you move and administer these interests, you do so in a manner that is fair, equitable, and just. Because, like I said, there are very, very powerful remedies. I believe with bonds, not as much with. I mean, yeah, no, I guess you could, yeah, with posting them and with issuing them and settling them. Yeah, actually, there is quite a bit of remedy there. So that is something in the public. Now, there's quite a few different ways to approach a matter, given, handling one particular aspect of a particular case. There's a few different aspects, that you can be aware of. One is the actual argument itself, the actual argument or the brief or the suit. Will generally, that's one way of essentially swaying the court in your favor, essentially by overcoming the duty to produce evidence and overcome those burdens of proof. Once you overcome those burdens of proof and you do that, your argument itself on the merits and the way it's presented is one of those ways that you can, as far as strategy. Now, because court is always based on that type of thing, it should always be a part of your strategy to have a very airtight and conclusive, especially your charging documents. But not only that, but how will you move the presumption and the perception, not only by the court, by the other parties, of how the court is essentially, like whether your case has merits or not. I won't be too wordy with it. Essentially, if your case has merits, right, it not only needs to be presented in a particular fashion, it also must be, have substance or, to the argument, right? And then on top of that, there are certain nuances, in certain things, but that's one plain strategy, right? You just attack it with the highest possible authorities, and then you have supporting evidence, but it's not crazy, but it meets your burdens of proof. All right, that's one way. There are other ways, right? There are plenty of ways people have won court cases by demanding an answer through a particular reasonable question that they're then compelled to answer but cannot without incriminating themselves. That is another very handy method of dealing with, litigation, especially because if it's essentially like getting checkmate on a chess, right? If you essentially, because people don't understand, like I'm gonna, chess is a game where the whole point is the chessboard is the symbolic representation of essentially the meeting of the minds. If you have everything, in such a, construed in such a way that you everything on the board suddenly just feels suffocating, like you can't move pieces, you can't do anything, your options become limited, and all that, and you still manage to come in and essentially, force their hand, all the way at the end of the game, you're in checkmate. you're looking to just, get what you want, right? Well, there's a reason why there's such a doctrine, or I guess a practice, if you will, with chess players always being more willing to resign in situations where they have the clear disadvantage and there's no way they could reasonably win, um, as opposed to just a straight checkmate, right? So a straight checkmate is like, you know, that's the follow through with the execution, everything, right? You won the game, you slam dunked, you broke the backboard, you pulled a shack, and you're just there, right? One step removed from that is just getting enough points to win the game. So, you can essentially get it by a technicality, or you can get them into a point where they can't say anything further. And if they can't say anything further or rebut any presumptions, then they continue to mount up. And then at a certain point, it just breaks. It breaks in your favor, and then they can't swing that presumption anymore. So, but and essentially the whole goal of the game is to have them resign, or admit or something, to essentially give you what you want. I mean, essentially, anytime wars have been fought in the past, any type of conflict, any type of argument per se, especially a serious one, has always been some type of where was I going with that? But yeah, it's generally all like, it's always been some type of, okay, I need something, right? And you're not agreeing with me, but I still need that thing. And or I have a claim, or whatever the case may be. I want, I'm entitled to whatever the rights of the party is. You're essentially looking to reclaim, and both perspectives say they're both right in their own eyes, right? The only thing left is either war of a couple different methods. It's either on paper, dealing with court, which is essentially what it is. It's a war on paper. And the other method is like actual battle, which is why we have the laws of nations, the laws of war, the Hague Conventions, the Geneva Conventions, all that. So, don't get it twisted. Court is essentially still war, but it's essentially mediated, and it's essentially like a game. It requires consent. You have to play by the rules, and you can't cheat. If you cheat, you automatically lose. It's the same thing. It becomes, in essence, a game, because you have to participate. You have to essentially agree to some degree, with regard to subject matter jurisdiction or whatnot. They essentially move everything in that particular space, right? So but the whole goal of the game is essentially to have, everything intangibly, like, all of your different evidence and information, to like such a pressing degree that they just give up. I mean, that's the whole point. You're really just looking to say, look, the judge is just there to say, look, he's a clear winner. He's followed these rules, and all this stuff. That's it. And if it's not clear, then this party still wins. Whatever the case may be. But the whole point is to have, like the strategy as far as litigation and other just resolving the matter, is not just litigation, but just, dealing with any type of conflict. So you always generally have to go to a higher power, right? Escalation. So if it's, you gotta, if when you're dealing with the matter, right? If it's in the contract, if there's no arbitration clause, then arbitration doesn't govern. And then the standard courts. So you'd be dealing with who has subject matter jurisdiction, and what is the status and domicile of the parties, and have the courts effectively obtain that jurisdiction, right? So this is when they look to, especially if the litigants are in different states, they say plaintiff is in this state, defendant is in this state. Whether or not you get to file it in one or the other depends on the substance of the matter. And also the statutes, because the statutes, certain law forms will be more favorable than others. But yeah, so over collateralization is the practice of securing a loan with the collateral that exceeds the value of the loan. I gotta read that again. Over collateralization is the practice of securing a loan with collateral that exceeds the value of... Oh, I see what you're saying. Yeah, that just comes down to in interests, like security interests and other, real property interests, and yeah, I mean, they're not gonna say it's over collateralization because they're gonna say it's attached to the original principal on the the note. So that's kind of a nuanced thing with mortgages, but yeah. But I mean, everything is done. Like I said, there's two different rules that I particularly pay attention to. One is called the rule of three. So the rule of three is essentially what everything publicly operates on: rights, titles, and interests, care, custody, control, A, B, C, 1, 2, 3. What else? There's a myriad of different ones, right? You know, um, trustee, a grantor, trustee, beneficiary. Um, bills of exchange, drawer, drawee, and payee. It's very similar. So you just have to think about what is your desired, effect, and what does it take to get there. Is there opposition? And if there is opposition, what will it take to overcome that opposition the correct way in the court? And remember, you deal with things in kind, right? When you're dealing with something intangible, so let's say I came up with, let's just say, a particular entity, and I'm, like I said, I'm not trying to infringe on anyone. If you got this business name, I'm sorry, I'm not looking to use your stuff, but let's just say, for example, John Doe Enterprises, or whatever, something along those lines, right? ABC 123 Enterprises. So if I came up with that particular thing, right, the entity itself, even though incorporated into the state, once it's filed the articles of incorporation, it essentially is treated like it's then it from not then on. It has a status, it's for a particular purpose, under business, for profit, by these people, for these people, and under these circumstances, right? If for some reason I need to amend that or move it or do something with it, I have to deal with that particular thing in like nature, right? That corporation is not tangible. Unless, the thing that I think people get as far as association with, tangible and intangible things is that, we associate the corporeal property of corporations and businesses, which are intangible. They're nothing more than a name representing a certain set of circumstances or conditions of people doing business. So that particular name, ABC 123 Enterprises, right? It's incorporated. It's just a name. That's really all it is. So that particular name doesn't, whether it exists or not as a creation of, law or creation of man as an entity or ens legis, is determined whether or not it's filed properly and acknowledged by, the state, right? If, if I'm dealing with the intangible interest in that respect, though, the papers or the articles of organization, or excuse me, for an LLC, or the articles of incorporation for a corporation, essentially, they only represent, the intangible aspect, right? Because quite literally, it is just a bunch of words and letters on the page, right? But it imports meaning, to that particular name once spoken, and or read and interpreted, and then it also talks about the intangible aspect, right? That intangible aspect exists only in the mind, and things dealing with the mental plane generally deal with fifth dimensional energy, which is you're not dealing with just length, width, height, you're not dealing with time. You're dealing with the intangible aspect. A thing is vibrating in a higher frequency than what can corporeally, manifest as. And as such, it loses speed and frequency, and as such, it becomes slower. And then because it's vibrating at such a high frequency that once it drops down to that frequency and it it materializes either through someone's active creation or some other reason, that particular thing holds that frequency, that prime resonant frequency, and that frequency is evidenced by that name. That name is identified as that thing and as what it's called. So anytime you invoke that particular name, sound, call in creation, you are moving that particular thing when they're tangible or intangible. This is why they say that we only see like 1% of the visible spectrum of light, because the remainder of all of the other frequencies are either essentially vibrating either higher than what is in the corporeal realm, or lower than what is in the corporeal realm. If something is higher in the corporeal realm, it will not be tangible. If something is lower than the frequency, the bare minimum frequency for the corporeal realm, it might turn to something physical, but it'll disintegrate or dissolve or whatever. So that is something, just so that you get an understanding of. Like, these things, you affect them in the mind. They only they only exist in the mind. But the danger with this type of thing is that everything that we deal with in the mind affects everything in our corporeal reality. So you have to keep those things in mind. But those are just some thoughts. And the other rule that I was talking about is the rule of two. The rule of two, and like I said, both of these are coming from Star Wars. So I think the rule of two definitely comes from Star Wars, and I want to say the rule of three also comes from it. But they are also mirrored in other occult, circles and other things. They talk about it. It's not just, one place that talks about those two particular things. It's a commonality and a theme. So yeah, the rule of two is essentially public, private, white, black, up, down, left, right, red versus blue, that whole thing, right? So that has been, essentially you get that dichotomy with one separation of the realms, right? So you have, just that duality of opposites. And then, the rule of three is a little bit slightly different. But so generally why I say the rule of two is because in Star Wars, where that I was referencing, they talk about how they call them Sith. They're the people, the wicked, right? The wicked essentially ruled with a public, show figurehead from a private, hidden, disclosed administrator. That's generally why, what they talk about when I'm talking about the rule of two, and it coming from Star Wars, that's what I'm generally talking about. So yeah, those are definitely some things to be aware of as far as, how you deal with this type of stuff. So the more, since you're dealing with all these things, and like I said, it does get to a degree where nothing's tangible, in that aspect, and you're trying to figure out what is really, especially if you don't have a strong grasp on it, it can be pretty taxing and give you a headache after a while. But knowing how to mentally picture this thing. Now, I will say that I didn't have as hard of a time with envisioning things, right? It's a or conceptualization or visualization in your mind. It's a process, essentially. Most people, you picture it. Some people are better than others. Other people learn way better auditorily, and some people learn kinesthetically by doing stuff. So there's generally three methods of learning in that essence. So auditory, visual, and by doing it. So muscle memory, or what the hand does, the mind remembers. So when you do these things, right? So the way that I started getting good at picturing things in my mind was by literally remembering. Because if you can, and I believe that most people should be able to do this to a fair degree without too much difficulty. You know, I realize that a lot of people have their pineal glands calcified, just to a good extent, but people that are detoxing will be able to tell. So first, I generally, if I'm trying to memorize anything or put some piece of information in my mind, for me personally, nothing will stick if it's not true. So I personally, it has to resonate with me. So if it doesn't resonate, if it isn't even relevant to my path, my future path, and where I want to end up, generally I'm less inclined to listen to it, because if it's not going to affect me in any way, shape, or form, why bother? It's kind of one of those trivia pieces of information. It's like, oh, game show, okay. That doesn't actually mean anything. So, yeah. So one, I look at the page, right? I, look at it, read, the document or whatever it is that I'm memorizing or studying a bunch of different times, right? I'll go through and just remember it. Sit there and stare at it. All the different details, the image at large, not focusing on anything, entirely. And then also, again, reading the individual details and going back in through. Now, how many times you have to do this to remember the image in your mind? Because then it goes to past memory, right? I don't know how many times it's going to take you. Everyone's different. This is just kind of my process of how I have to learn things, or especially one of the easiest ways I've used to learn things. And to me, once you get past a certain aspect of things and you can form more of a mental map, because let's say you've looked at these documents and these documents and these documents, and you remember them very clearly and all that from the amount of times of repetition, and giving yourself, repetition, consistency, but also giving yourself the necessary time and breaks and rest to let it sink in, you'll be surprised what you remember. Another thing is, like I said, memory is most of the time generally predicated upon an emotion that that is connected or tied into the memory that we are trying to keep. Why is it that past traumas are so so effective at essentially captivating, and not in the positive sense, making people prisoner to their essentially their past traumas? Well, the reason is because that past emotion was not dealt with, and it was left to resolve later, right? But why is it that we were remembering that in the first place? It was because of the emotional tie or the emotional attachment between whatever it was, the memory, the information, the circumstances, the situation, and the emotion itself. So if for some reason we hold on to a particular emotion, generally you want to do this with positive emotions, but sometimes there's just, you hold on to it with this, you do the best you can, right? Some situations it's not always the best, and you don't always ruminate upon them 10 years down the road. But so yeah, an emotional tie to a particular memory, by remembering the emotional tie or the feeling of what you were doing, you can invoke the same passageways to a much longer degree, because generally when we have very strong emotions, it generally transmits to long-term memory much, much faster than it ever would. So, like I said, the same way with the emotional traumas, why people, especially people with PTSD or, even abuse and other things, war traumas, etc., People will go through a variety of different things, but that is the reason why it sticks so well, because it initiates that fight or flight. People are stuck dealing with, they got a backlog of emotion. That's essentially what is happening. So understanding that same concept and trying to translate that over to creating a positive, beneficial association between, a particular given information and maybe, let's say, its remedy, or like, so that's another thing that helps me remember and correlate different pieces of information that may be seemingly irrelevant except for one particular aspect, is a piece of like an information, or a piece of information that has particular use. So if information is particularly useful and can be utilized or leveraged in a way to bolster, an argument or obtain a desired result in the court, that is something that you should be aware of. So, and that's, that's something that I generally pay attention to, and it's easier for me to remember because I'm generally looking for solutions, right? There's millions and like billions in different problems, right? They're not really problems. They're really just opportunities to solve. But what problem do you want to solve? And how do you, what type of, generally I do things because I want to do things the right way the first time, and I don't want to have to come back the second time, or there ever be a second time. So generally I'm looking to, okay, what is the just overpowered, I like to think about it like this way, right? I played a few video games growing up. It's like, everyone knows, most people know about how you have to level up and just do side quests and just a bunch of random stuff in video games just to try to get ahead, right? If you're playing, let's say you're going up to the final boss, whatever, right? You just have, and you picture the final boss as being the burden of proof and overcoming the presumption, whatever of the court. That is the final boss. The judge is not your enemy. The court is not your enemy. The other party ain't, well, I don't know. That's up to you. But if you only need to worry about essentially what you need to do in the court. What they can do, unless it's going to affect you, it doesn't really matter. Yeah. Well, the other core concept is that energy can be expressed in several different forms, but like in its sound, like in its wave function, energy, because like I said, energy can travel as a wave or a particle, right? So when we get electric shock, generally we're not shocking ourselves like electric eels, right? So generally speaking, when we deal with energy in our bodies, other than the bioelectric, impulses and communications and synapses between the different cells and the various parts and organs of your body, right? Generally speaking, aside from that direct collapsed function, which would be that particle form, the actual energy inside the lines, not the general energy outside traveling around the wires. That is the wave function, because the other aspect of it that they don't talk about is that since energy travels in both forms, people only look to collapsed functions. So they only look to think of the energy flowing directly in the wire, and they think that, that's the only form of electricity. As long as you don't touch the wire, that's it, right? It's not the case. Because the opposite form of energy is when it's no longer just collapsed into, a particular, what is that? That would technically be like one-dimensional, I think, if I'm not mistaken, but is that wave function, right? So when energy travels as a wave, it is generally traveling as sound. Now, what determines what that sound, manifests as is going to be determined by the frequency of that sound. So that frequency of the sound is going to be what determines all of that. But when we have, emotional matters, right? Etheric energy and all that, it moves just like water. And emotions go up and down all the time, like people feel like, they talk about relationships. Well, what water are you sailing? You're sailing, like, essentially emotions. So the same way, though, from those higher realms, the emotions and other things, essentially manifest in the corporeal aspect through the like nature of the water in our bodies and the watery likeness of emotions. But it wasn't, like I said, it's not directly, it is relevant to what we're talking about, but it's more of something just to keep in mind, as more of like how, just something to keep in mind of. But you're really just tracking the movement of energy, the movement of sound in the court, right? Because when you talk about relevancy, like, I just tend to think of, what is my most pressing, task or obligation that I have to fulfill in this case, right? Have I fulfilled all my obligations? And then, I have, let's say I've done everything previously to that, and then, that burden shifts. Well, as soon as that burden shifts, I generally do my best to take care of it right away, because delay is not, it doesn't help you, especially if you're trying to keep the momentum going. If you delay while you have the ball, then it's going to land more towards the other side getting it, and pushing that momentum towards the other side. Because in court, you have two things: you have effort or work, and you have momentum. Momentum in the court is when things are going in particular favor of a particular party, right? And the effort or the work is simply the bare minimum necessary energy that it takes to accomplish, a percentage, or a part of that, of pushing that invisible wall, or that presumption of guilt onto the other party. So that's just something that I think about when I go in there. So you always want to be coming in with clean hands and understand, why you're even coming into the court in the first place, and leave arrogance at the door, because it really doesn't do anything. Yeah, because judges have, realistically speaking, judges love to humble people. And it's not something that, it's not fun to watch. I've seen a bunch of court cases. So, yeah. But just with the stuff that we've talked about, any other thoughts, any other questions? You really just have to deal with whatever matter it is and stay in. Because, one thing I see a lot of people do is they get slack-handed. Like, if you've got a bunch of matters, right, and you're dealing with it, and you're 2-3 different cases all coming at you, you're named as defendant and all these different things, those are the most pressing matters, like, by far. Especially when you're named as the defendant or respondent in any type of suit, that's gonna which sometimes, like, generally all courts, you're gonna, if you have multiple cases going on at the same time, you're gonna have to be responding to them in parallel. There's no other way to do it. But if you are taking proactive measures, make sure you don't open up, like, more than one or maybe 2 lawsuits at a time, because you don't want to put yourself in a position where you have to respond, and and all this stuff, and you're dealing with everything all at once. There are situations that happen like that, I get it, but yeah. So, but yeah, so managing, and the other aspect of this is people's perceptions are so often influenced by emotion. Now, people always think, oh, it's always legal, or it's the left brain is always calculating and all this stuff and all that, and it's like, that's what courts are, right? I don't think people truly understand, like, the aspects of where the different parts of the brain go in with law. You do have to develop, You're understanding to a point where you're able to deal with things either way. But when you are dealing with because the left part of the brain deals with um, parameters, conformity, structure, order, deduction, reason, things like that, right? The other side of the brain, the right side, the right hemisphere, deals with creativity. It deals with, um, you know, like new experiences, new opportunities, intuition, um, not necessarily knowing these things, or not necessarily knowing the next steps to take, but knowing that you'll get to a particular destination or what have you. That's the difference between the two, right? So some people have a natural inclination towards one or the other, but you do have to balance kind of both and know what your strong suits are and what your weaknesses are, so that you can focus and improve everything overall. So in the court, knowing what you can and can't do will generally comport to the left side of the brain. So knowing the statutes, what are the general principles, what that and all that, right? But equity is more of a creative process, right? It's based on things of fairness. There's no set structure or rigid structure, or even better yet, that rigid structure might actually fail in its intended purpose of administering justice, right? So, what does equity do? Well, that's where the equity maxims essentially fill that void, and then you're dealing with, okay, well, it's not essentially left brain, all of its perfect circuitry. You essentially have to create that circuitry to get to that end result. And you use different building blocks. You use maxims and case sites in the private, as well as other, encyclopedias or jurisprudences and dictionaries. But, that's what you're dealing with, as opposed to a more rigid statutory, everything is this and this and this, and this is what you get. As opposed to, there's no real clear, statutory remedy that's conclusive and able to solve all of these different issues in this court case. So I'm going to essentially, you know, um, operate on both sides, right? So what I mean by that is obtaining public remedies and, private relief, from all, private, standpoint, because equity regards as done what ought to have been done, and what is it? Equity delights to do justice and not by halves. So yeah, so those are some of the biggest considerations in dealing with court. The other aspect of court that most people don't really take into account is the pressure, both why you're actually in the building and why you have the duty to respond, because it can be a lot. People, realistically speaking, like, people get PTSD from court cases that don't go well. Especially when they're young, especially dealing with custody and child, proceedings and stuff like that. Yeah. Oh yeah. Children remember that much more than they're willing to let on. So just children are more open towards certain things than people are now. So, but yeah, understanding how emotions work, the nuances of emotions, how you can, certain words or certain phrases or even phrasings or presenting certain things in a certain order or a certain time, essentially, sway all that water and cause all that water to come crashing in the other direction, right? Because that's when I talk about, momentum. Because if you think about it as, when you're dealing with that case is like a cup or a jar or something, right? And you put a lid on it, and I don't know. Let's just say, for example, right? You're just spinning it. You tie a string around the jar, and you're spinning it on a loop. All the water, let's say you only fill it up halfway full, right? All that water is going to be at the farthest end of the jar, and none of it's going to be near the lid, as long as you got the bottom swinging out. So that same thing, right? And then you could do that in the opposite direction. Like you could tie this, figure out a way to swing it with the cap, facing outward. But essentially, you're just looking to sway all that water. Now, when you're dealing with moving water, you can't just take a couple drops and move that. You have to move the whole container to move the water, or you have to have some big force or some big wall to move a great majority of it at a time. That's generally how I think of as far as perception. The who has control of the perception and the presumptions and all that generally has control of the court. The ambiguity of things, I've just gotten to the point where people in my past thought I was wordsmithing and making mountains out of molehills, but I just kind of come from the aspect of, if things have different names, generally they're probably different things, unless they are known to be the same, and then they might just denote different aspects or different languages in which they were given, or but ambiguity, I mean, I don't know. Part of it is that I grew up in such a legalistic and structure and over structure and all that environment when I was growing up, that I was always looking for freedom. So, I mean, freedom is essentially, when you think about what freedom is the ability to make a choice. That's it. It's to be able to make a choice and do what you want. That's autonomy, right? So, how do I deal with the ambiguity? Well, generally speaking, I don't want to be confined into a couple different possibilities. So, generally speaking, when I manage the presumptions of the court, by my pleadings, I'm looking to do, every single thing that I got to do, take care of all my obligations, and then say, oh look, I did everything that I was supposed to do. And then it just, so that same thing, so now that takes away like people that really are going from this as an honest perspective and they really don't know, an outsider looking in from the court case, that type of perspective. Now they're looking at the case going, oh shoot, okay, well, he did all this. So then, that same way where you kind of turn on it, you have a change of thought or a change of the way that you view a particular, party. Now, when you show that you've done everything that you're supposed to do, right? And you've shown not only that the other party does have unclean hands, like they did actually do something. Now, the emotions change, because the individual circumstances or the facts being presented in the light change the way the picture looks overall, right? Another way to think about this is like details in a movie, right? Some movies are A grade, and they lend to an atmosphere or a vibe or something in a movie that it has a particular feel, right? And it's the same way. Good A grade movies with big budgets and as long as it's well written and a good story and all that, yeah. I mean, they have that effect on people, right? That sways their emotion. That's why they tend to, when they work on those individual elements of the movie, and all of those individual elements correspond to make a good or an excellent overall film, people go and it usually blows up, because they've done their best to manage the emotions, manage what is being presented, and present it in such a manner that they invoke those particular emotions they wanted the viewer to feel. That is the same way that you have to think about what you're saying and presenting into the court. Because there's always, like I said, there's always two different levels, right? You can be seen and you can be like, or you can be seen and you can be like noticed, right? Because somebody can see you without noticing. They're just doing whatever, and you don't really stand out. But if they notice, they took some time out. They did what's called a respect or a double take. Because if you respect someone, that means you literally have to look at them again. That's literally what that translates to. So when you're just doing that, like, You just, like I said, you just want to manage that presumption and understanding that feeling of, and what causes it, like, moving that little gut wrenching feeling, like as far as, a narrative, because the narrative that you have to consider is what is openly accepted or accepted by the court. That is what will control. Because on one side you have his story, and on one side you have his story, right? But what is the overall narrative? The overall narrative is where you're dealing with the presumption. Right. Inspect means to take a look in. Spec, yeah, spec or spic means to look, right? So a spectator watches. Someone that has to respect someone else means that you can't just treat them like someone else on the street. You have to literally check yourself and look again. That's what respect means. So, it means that you are worthy of a second look. So, but, in that same essence, there's like two levels to that. There's knowing, and then there's understanding, or knowing and then knowing and understanding, right? Simply just knowing certain bits of knowledge, well, and not knowing how to properly apply them, it doesn't do what you think it doesn't have the desired effect. But, when you have the understanding and the knowledge, right? So you have the knowledge, but also how to apply it. That is far more with regards to manifestation and obtaining the desired result than any of those other things, because you're going to be dealing with that emotion being funneled into, essentially, because you're really trying to, think about it this way, for example, just for the sake of, you know giving that kind of iteration. So if for some reason you have, like I mentioned, the history, his story on one side, your story, which would be a his story to him, and his story, and then you have the overall narrative in the court, and that is, and I'm talking about just the spotlight. What is the evidence that is actively accepted into the court? What has been filed and docketed and properly accepted and noticed to the other party? What has been, sufficient with regards to, what would you call that? Shoot, just you made sure that you did all those things. But, the bigger point that I'm trying to make is there's that deeper level to it, right? And you don't have to be an expert in court to understand that. Generally, if you've been through a few things, you don't have to go through crazy things in life. If you've been through a few things, you know, everyone's been through some kind of tough situation. Some people haven't. It just depends. But, understanding the depth, and the view. Now, the clerk will control a lot of what is accepted into the narrative, because what you're dealing with, where the limelight is what is accepted into the court, and it's all of it's met the statutory requirements as far as filings and notices and all that, and the motions, and it's all proper. So you're able to manage that. So whenever you think of what the judge is thinking of, he's looking at that spotlight. He's considering the other stuff, but he's not allowed to take that other stuff into real consideration unless he has like evidence, admission of one of the parties, or there's like some clear way to infer something. Other than that, they're looking to, only that limelight. They're acting like they can't see it if it hasn't been properly filed and all that and treated according to that manner. So when you picture that in your mind, and you see what's before all of your papers in front of that, and that judge, and what you need to, put into the court so that you can draw, or you can, draw on that particular document and your argument, or either in chambers or in public, or however you handle whatever matter you're dealing with, that's the type of thing that you want to remember. So, and in court, it's yeah, you're gonna definitely want, wisdom and understanding more so than just general knowledge, because if you either don't have the expertise or the experience, and you have some type of matter, don't just wait. Like I said, if you don't know how to do anything and you don't even want to represent yourself, go get an attorney. If you want to be awarded court, that's essentially what it'll do. But my lane is essentially just teaching and training others essentially how to deal with things using exclusive equity. Exclusive equity is fair and just, right? It's kind of that hidden loophole where they presume that the law is just until you prove it otherwise. This is why when they talk about the unconstitutionality of a statute, or generally speaking, yeah. Now, getting into equity, and as far as like private, in chambers, in camera, in um, sealed proceedings, stuff like that, yeah, you'll definitely want to make sure that you go and you handle that accordingly to the matter. But generally, when you present that evidence in front of the court, can you expand more about the motions and how they correlate to the flow of things with the court processes? Absolutely. So, I mean, this is, well, if we're going to talk about that, I'll just go over like a brief description of how the court documents essentially work. And again, this is not legal advice, but just as a kind of training and commenting perspective, the court works in the manner of, on the principle of notice, right? The court is essentially a forum. It's an avenue or a venue, and it's essentially a mode. It's a mode of resolution of disputes. So, mediation is another one. Alternative dispute resolution, ADR, that's the same thing that I'm talking about. And the courts. So you are looking to resolve the matter. So what it takes to get to that to resolve that is going to be determined by what you need. I can't really go into specifics because it's not, like I said, it's not advice. But so generally, to start any type of suit, you have to have a charging document, right? So the initial burden of proof in the court is that you have to overcome before you ever file anything is, do I have evidence of wrongdoing in the case or in this matter, right? Do I have evidence that I can validly prove, that I am entitled to some particular, relief or, compensation for this breach, and here's the evidence of breach, right? What is the prior past history regarding this and this in similar circumstances? And here's what I'm requesting. Here's my standing, here's my status. This is me, however you put it on the paper. That's what a charging document is. So what is a charging document? Complaint, right? A sworn, or I don't swear, so I do verified complaints, right? Declarations under penalty of perjury. So you have that. Then you also have the other documents. So there are judicial notices. There are notices of hearing. There are notices of motion. So you have your individual notices, right? Anytime, just for example, right? The reasoning behind it, like all these different notices, is that there are individual aspects of a court process that may or may not be deemed to hinder or essentially, not just hinder, but effectively deny due process, but because it would be inequitable to allow certain things to be ex parte, right? And what I mean by ex parte means out of one side. So Ex parte means any communications by one party to the court without notification to the other party. That constitutes ex parte communication. Ex parte communication, they they really don't like, self-represented litigants. You know, so a lot of times, if they're really trying to do certain, if you're harassing the judge's chambers or something like that, which is not recommended. Generally, that's the kind of thing that might happen in that aspect. But they, yeah. So you have your charging document, which is usually your initial complaint, and petitions. So what is the difference between a complaint versus a petition? A complaint is you're demanding punishment, right? Or essentially, with just a complaint by itself, you're essentially looking for the other party to be punished, right? That's civil. Everything's punitive, it's all penalized. There's no real. It's just there, right? That's all civil is. Now, what we have today is this whole post 1938, like I said, Erie doctrine of the whole court system. So the fusion of statutory equity with statutory at-law provisions, and we have this whole unclear, messy system now. So, now it's just the courts. They either have powers of equity or they don't. Generally, most courts have some type of statutory provision allowing them to even exist, but the powers to compel a party to, uphold a contract, the power to prevent a named party from taking a particular action to the prejudice of the other party. That is something that is an equitable power that's the court has as well. What is another thing? That like there's a bunch of different things there that you can essentially use in equity, and those are all equitable remedies or equitable relief that can be granted even by a court at law. Now, how that is accessed in the law, that's different. That's a private conversation. You're dealing with trade secrets and all that stuff at that point. But I mean, yeah, getting to the court, and the motions itself are essentially how the court moves, right? But because you don't control the court, it is a request. Because you are not the court itself. You are a party before the court. So if you're just a party before the court and you can't control the whole thing, then it remains a request. So motions can be urgent, they can be emergency motions, there can be other types of regular motions, etc., right? So those motions you are moving the court to either order or do a particular thing, right? So let's say, for example, you need a hearing set, right? And it's not a normal case, and you need to be heard in chambers or something like that. You need to put in a motion for that particular type of hearing. So that motion what your request or your it's essentially, I'm moving to, the way that you could look at a motion in a court is, I'm moving to take this particular action right now. And if the court does not disagree with me, I will continue. And then you're just looking for the court to confirm what you're essentially stating in that public side motion. Now, things in support of your motion, unless they're specifically sealed, generally need to be accompanying the motion itself. And again, a lot of this varies by jurisdiction and all that. So this is just generalities, like, for the moment, but this gives you a better idea of that. So you have charging documents. So petition is literally a request. Your petition is literally your request. So with petitions, it is petitioner and respondent. The petitioner would be akin to the plaintiff, and the respondent would be the defendant. Akin to it, anyway. Plaintiff and defendant is more of an at-law civil type of manner, although because the venue is civil, and that even if your matter or the substance of the argument may not actually be civil in nature, it might be equitable. The forum itself is civil, so you don't breach the equitable matter by putting the equitable matter in the civil side of the venue, as opposed to how it's normally handled discretionarily. So, yeah, so that is something there. I mean, absolutely. Equity has been misconstrued by design, but I don't think it's really been misconstrued so much as just been hidden. I mean, well, and to part of that is kind of a blurred line between what is what, as far as blurred or hidden, or hidden and obscured. But yeah, no, I mean, generally they don't want to deal with equity because equity is the undoing of all unjust laws. Unjust laws are not law. So that's why generally people don't like certain things. And I'm not saying that there aren't just laws, but there is, at least under modern statutory scheme, there is a tendency, a very, very heavy tendency and precedent towards, not trying to do anything equitably. Like there's a lot of things that are being taken out of context because people don't understand. But the only thing you can really do to remedy that is to understand things for yourself. You can't, you know, can't force anyone else to deal with it for you or what have you. So, yeah. Any other thoughts? No? So, but yeah. So, make sure that you do what you can ahead of time before the court. Have all your argument won, essentially, before you ever go into court. So that when you have to go into court, or if you don't, then you're just dealing with whatever you gotta do. So that way that you don't have this absurd pressure from the other side. Court itself is already stressful enough, but when you allow that like procrastination from dealing with things, it just multiplies. So I don't recommend it. So yeah, save yourself the anxiety and the panic attacks, and just take care of what you need to when you're supposed to. Would probate work more after 1938? Probably, although technically probate has had a loophole in jurisdiction for hundreds of years, I think. It's not conclusive. I mean, it's still... Like, for example, like, I can't really talk about too much on that, but for the cases of, like, let's say, for example, in cases where someone is presumed dead, right? People that are presumed deceased or dead, generally, there is a long and stringent process to legally proving that you are deceased. So the only way to really deal with that type of thing is essentially just deal with it at its highest level, and only with the necessary, like, the bare minimum prerequisites, like name change and other things. And like I said, you can go through probate, but it just depends. It really just depends. It's a whole other language that people aren't generally familiar with. But no, it's not too chilly. It's not. And court language is fairly A lot of it's very detailed. If you just picture this and then you just picture everything as like hierarchies and different lists of, you know, incorporated into each other, as long as it's over the thing and it's so, superior to whatever it is, generally that's just how I remember stuff. I just remember what law forms are over what, certain things, and a lot of it comes down to the situation and construing it in the manner that it should have been from the start. So that is going to be a large part of it. But any other thoughts? Probably go another 10 minutes. Yeah, no, you need a contract after 1938. But you have to produce the contract. So, yeah. That was the other thing that people were having a hard time with. People were trying to go to court and settle all their minor accounts without evidence of the contract or the agreement. So you got to prove your claim. If you don't provide proof of your claim, then it's kind of baseless. Yeah. So yep. Maxims help a lot. Maxims prove principles and case law proves situations. So you can't guarantee all situations, but principles are always there. It's just figuring out which ones apply to the situation. Yeah. Maxims are law. I mean, there are some unjust maxims, don't get me wrong, but people gave rise to them through their actions. Yeah, case cites, maxims. It's a few different things. And another quick thing to consider is who owns the name. That's the name in question. Is it an LLC? Is it a corporation? Is it a sole proprietorship? Is it an estate? Is it a trust? Who owns the name? How is the name held? Are there multiple owners? Are there conditions precedent on certain forms of ownership? So, yep. So yeah, a lot of the remedies for things are actually really private. So I won't cover those as much on my public side, especially not on my channel as much. I do my best, but I'm just at a point where most of the remedies I have are private. So there are some, but there really wouldn't be a remedy if it was everyone knew about it. Oh wow. Certified parts of the Bill of Rights. Well, yeah. Most people don't actually have standing under the Bill of Rights, so I'm not really surprised. So, if you need to set up a consultation, let me know. If you need to set up a trust, I have services for that available as well. We'll be holding a custody and child support, masterclass, with regards to exclusive equity. That will be happening March 31st. Is it 31st? Yeah, March 31st, April 7th, April 14th, and April 21st. So those 4 days is going to be one masterclass. It'll be once weekly on Zoom. So the first 10 people will be 250, and then from there on out, it'll be 500. The replays will be available, and like I said, all the calls will be, those 4 calls will be recorded, and you'll have access to the replays after. So if you need assistance in any other matters, please let me know. Check out my website. And other than that, hope this has been insightful. Like I said, this is just an impromptu live, just to help to, like I said, provide more value. Hope it's provided some. So all praises to the Most High, and I'll talk with y'all soon.